Labrit. Thank you very much, the organizers, for inviting me to this event. I'm particularly exciting being here in Riga, because Riga also has this special place in my heart, because I've spent 1 year studying here and also being classmates with Mr. Laganovskis. And this morning I gave a short walk in the downtown of Riga and noticed that it became even more beautiful. So it's a bit of shame on me because I visited only after 16 years, but I promised to come back early. So the topic of my presentation today, disclosure of designs in the internet, is quite specific one. So if during the presentation you have any doubts or cannot follow me, just raise your hands, and I will try to stop and explain a bit the issue. So as a preliminary point, it should be noted that although the regulation on the community designs covered both the registered and non-registered design, the focus of this presentation will be on the registered designs, in particular because our office deals mainly and only with the registered designs. However, the principles relating to the disclosure of designs are equally applicable to the non-registered designs. So my presentation will cover the following topics. I will give you a very basic introduction of what is a disclosure of design, what are the general requirements. Then I will go into the specific topics, specific aspects related to the disclosure of designs in the internet, such as types of evidence when proving the disclosure on the internet, searchability of information, accessibility, how to prove the date of disclosure in the internet, disclosure in the social media, what are the specificities. Also, I will partly cover the current practice of the office and the courts regarding this issue, and finally I will conclude on the convergence of practices, which is the new initiative which is ongoing on this topic. Okay. So before going into the specificities of the topic, let's take a look in the context of the disclosure when it comes into play. And it comes into play when we talk about the invalidity proceedings of designs. At this point, I would like to do some promotion of the EU system of the registration, because the EU system is a unitary system, and it gives from the single application the protection in all the 28 EU member states. It's quite fast. Sometimes the design can be registered in as few as 2 days. So, because only the basic things are checked, that the application meets the definition of design, and it's not against public policy and morality. And if the formal requirements are met, then it's registered. And only after the registration, the interested parties can challenge the validity of the designs on the grounds which are provided in the Article 25 of Design Regulation. And two of these grounds are lack of novelty and lack of individual character. So when we talk about the lack of novelty, Article 5 of Community Design Regulation provides the requirement that the design has to be new. It means that no identical designs has been made available to the public before. The same with the individual character. Then it must have an individual character if the overall impression it produces on the informed user differs from the overall impression of the design which was made available before. So if the design does not meet any of these conditions, it will be declared as invalid. And the action basically on the invalidity can be brought by any interested party. And when we talk about the earlier design, which was disclosed before, it could be in the form of design, it could be in the form of trademark, patent, utility model, it doesn't matter really. Okay, so as it can be seen from the Article 5 and 6 of the regulation. When challenging the registered community design on the basis of lack of novelty and lack of individual character, the preliminary question is whether the earlier design was made available to the public before the filing date or before the priority date if the priority was claimed. And as you can see from Article 7, which is quite a complex article and talks about the issue of the disclosure, the assessment of disclosure basically consists of two parts. So first of all, you assess the event of disclosure, whether it really happened before the filing date. And the article says that design shall be considered as made available to the public if it was published, exhibited, or used in trade, or otherwise disclosed. So the forms of disclosure can be very different. And then the second part gives you an exception to the disclosure. And it says, except where these events could not reasonably have become known in the normal course of business to the circles specialized in the sector concerned operating within the European Union. So this exception part is quite complex and covers many conditions and which are open to the interpretation, such as reasonably become known, normal course of business, which gives a lot of room of interpretation, as I mentioned. In principle, only one event of disclosure is sufficient for the design to be considered as disclosed. Also, it should be said that the disclosure can happen anywhere in the world, and including internet. And finally, the part 2, which is in blue, provides an exception of the disclosure. It means that when the design was disclosed with the condition of confidentiality, such a disclosure will not be taken into account, and also when the design was disclosed by the designer himself during the 12th month prior to the filing. So it means that the law gives a designer a possibility to test a design before applying for its registration, and such a disclosure would not be considered as giving a grounds for the invalidity. So talking about disclosure of designs in the internet, from the office practice, I can tell you that the number of designs which are being disclosed in the internet is quite high, and it's been growing quite fast. Also, the evidence that originate from the internet, such as printouts from the web pages, are also quite common. So I would even say that in around 50% of invalidity cases, we get the evidence which are somehow related with the disclosure on the internet. And when we talk about the disclosure of on the internet, the distinction has to be made, first of all, about the events of disclosure and the evidence originating from the internet. So when we talk about the events of disclosure that happened in the internet, it's actually when the design, for example, is published on the website or is published on the Facebook account. However, when we talk about the evidence that originate from the internet, it's only that the evidence about the disclosure comes from the internet. Because sometimes it can happen that the design was disclosed in the real world, let's say in the exhibition, but only that information about such disclosure was found in the internet, on the website. So in that case, only the evidence itself is from the internet. However, it should be noted that the disclosure should be assessed as being in the real world. And it's also particularly important to make this distinction, what also the courts are doing when establishing when the disclosure was made. So when the design was for the first time disclosed on the internet, this will be the date of disclosure. However, when the design was disclosed in the trade fair, for example, but only that information was published in the internet, still the disclosure, the act of disclosure will be that of the first disclosure, which is in the real world, which is an important distinction to be made in your mind. due to the specificities of the internet, when talking about disclosure, the particular attention should be paid to the types of evidence which are acceptable when proving disclosure in the internet. Also the accessibility of information, searchability, because, for example, the holder of the design might claim, okay, that the information in the internet was somewhere hidden in the web page, and therefore it was not accessible to the public, and therefore no one could possibly knew about such a disclosure. Also, how to establish the date of disclosure, because you always have to prove that disclosure happened in the past. So these are the issues that I will address in the presentation further on. As regards the current practice and the case law, so first of all, I would like to mention that the guidelines on the examination of design and validity applications that the office has dedicates a specific part to the disclosure of designs in the internet. The explanation is quite brief, basically because the practice was not so well developed. However, the UIPO, for the time being, is the only EU office which has this provision explaining a bit to the public about the issue of disclosure in the internet. And currently, the guidelines of the Office on Design and Validity Applications are under the revision process, so hopefully we will elaborate a bit more on this issue. As to the case law of this specific topic, mainly these issues now been touched in the decisions of the invalidity division of the office or the boards of appeal. The court practice is not that developed so far. This year we have been quite lucky to have 2 brand new decisions from the General Court, which you can see on the screen, which is the decision from the 14th of March 2018, the case footwear, about the famous Crocs footwear. In that case, I happen to be the agent, so this case is particularly dear to me. And also the other judgment of the 27th of February of this year, which is cases for mobile phones, which also gives a lot of guidance on specific issues. So when we talk about the types of evidence that are acceptable for proving disclosure on the internet, as a preliminary point, it should be noted that the law does not give any guidance or does not give any requirement on the specific form that the evidence should be provided in. The Article 65 of Community Design Regulation gives a general list and examples of the documents that are acceptable as proof, as evidence. Also, the case law mentions the general principle that the general assessment of the whole evidence should be taken into account and that the evidence should be combined together. So in many cases, you will have a bunch of very different evidence proving disclosure, and you will have to make an overall assessment. So in one case, one piece of evidence would have a higher impact than in the other case. Okay. Yeah, so talking about the types, so typically the most common types of evidence used to prove the disclosure are, of course, printouts and screenshots of web pages. So when I'm talking about the printout, it's basically when you print the web page the way it is. And when we say about the screenshot, it's normally when you take a special part of the screenshot, make a photo or a shot of it, and present it as an evidence. In principle, the recommendation is that the printouts should be submitted as they are, without any kind of modifications. Then the evidential power of that printout, of that evidence, might be somehow affected if the office or if the court, if the case goes to the court, sees any additional details which are not very common to that printout. So for example, the case that I mentioned cases for mobile phones, in that case, the printouts had some additional information on the top, and therefore the Board of Appeal basically refused to accept them because of that feature. So therefore, when filing this type of evidence, the particular care should be made in order to make sure that the printout does not have anything which is apart from the information, because the issue of possibility to modify the information which is from the internet was addressed in that court decision, saying that yes, there is a possibility that information on the web page before printing can be easily modified. Nevertheless, it has to be shown that there was intention to modify such information. So therefore, in principle, when you print it out as it is, it should be accepted, unless there is something strange that the office would see in this type of evidence. URL addresses, sometimes the parties the invalidity applicants would just make a link or a copy or the reference to the link to the internet address, to the internet website. So the link itself, in principle, is not acceptable, because the office is not supposed to go and check the website. And also the link is not very useful because it does not really show the information which was in the past. Because when we talk about disclosure, we talk about whether the design was disclosed in the past. So if the office goes today in the website, it would really only see the information which is today. About the videos, also the office sometimes receives links to the videos. The problem is that the parties have a difficulty of submitting videos in the digital format, because disclosure can happen in the videos in the YouTube, for example, of the design, and you cannot really download the video from the YouTube. So the way that the invalidity applicants, they choose to submit, they submit the link. However, the link itself is not really a valuable asset. Therefore, what the office would recommend is to submit screenshots of the videos. So in these cases of inflatable toys and altitude mask, the screenshots of the videos were accepted as a proper evidence. The most important thing, when the screenshots are submitted, that the earlier design should be represented in all the angles. So it's not only sufficient to submit one screenshot, it should be the screenshot that really shows how the earlier design is. The other type of evidence which is also examined are the emails, because disclosure of the design can happen during the email communication. The general approach is that email is a private communication between the parties. So, and it's not available to the public at large. So even if the design is somehow disclosed in the email communication, in principle, it would not be taken into account. However, nowadays, the email communication has grown to a bit different level. So when we talk, for example, about the promotional emails, when the companies send the string of emails to different parties. So for instance, in the case of the general court cases for mobile phones, the disclosure was accepted as it was made in the email communication, which was sent by the Chinese company AliExpress, which is a big retailer in China, and it was sent to a lot of retailers, and the emails contained the early design. So in that case, the court said this looks like a proper evidence to disclose the earlier design. Also, in the case of inflatable toys, the Board of Appeal rejected the emails as evidence because they considered that these emails were sent between the traders. To my opinion, that approach was too strict, because at that point you also have to look into the nature of who are the parties in the email communication. because the regulation talks that the design should be disclosed to the circles specialized in the sector concerned. So if we talk about the communication between persons, let's say designers or traders, so in that case, even this communication probably would be considered as the disclosure, because we have a judgment from the European Court of Justice, which is the highest instance. The case is 479 of 2012, called Garden Furniture. And in that case, the Court of Justice said that it can be possible that disclosure, even for one undertaking, would be sufficient. So in that case, even if you might have an email communication between the two companies, which are specialized public, it could be sufficient in theory. And another type of evidence which the office frequently sees in the invalidity cases are the written statements in writing, which are sworn or affirmed like an affidavit. And this type of evidence is expressly mentioned in Article 65 of regulation as acceptable means of evidence. However, the practice of the office, and also which was supported by the General Court, is that the statements should normally be supported by additional evidence. So the mere statement in itself saying that this design was disclosed the time ago would be not sufficient. You have to submit something more. So one of the factors that has to be taken into account when considering the exception that the specialized circles could not really become aware of the disclosure is the accessibility of the information. In that case, I would say when assessing this factor, the office has quite a liberal approach. So for example, such an issue as whether the website where disclosure might have happened was protected by the password. So in some jurisdictions, some national offices would not accept such an information as being disclosed when the website was protected by a password. However, the office does not see any issue with that. Also with the payment, when the website was, to access the website, the payment was required, so the office might still consider that such information and disclosure of design in such website was okay. However, when we talk about the confidentiality, when the information was disclosed under the condition of confidentiality, let's say in the company's in-house intranet system or confidential email communication, in that case, the design would not be considered as disclosed. That it comes also this provision from the Article 7.1b, where it says that designs will not be considered as disclosed where they were made available to public with the condition of confidentiality. Also, the country code top-level domain name has to be taken into account when assessing a disclosure, where the website is. So, for example, if the website is from the European Union, so probably the public in the European Union could be aware of such a disclosure, and it was confirmed by the invalidity division in the Doors case. In that case, the website was from Bulgaria, and therefore the office considered that it was likely that the Bulgarian public was aware of such a disclosure. Also languages, it's important to take into account the languages. So for example, if we have a website in Swahili somewhere in the world, it might not be reasonable to consider that the European public could access such an information. I haven't mentioned the issue of blocking of websites. It's also important to take into account because there are some countries in the world who block access to the internet resources, and therefore, if there are indications that information was not accessible because of the blocking, so this should also be considered. Searchability of information. The holders, the design holders also use this argument that the specialized public was not able to find the websites in the search or because they are hidden somewhere in the internet, and therefore the design cannot be considered as disclosed. And the court, the general court, gave quite an extensive analysis to this issue in the footwear judgment, and shed some lights on the factors to be considered when assessing the searchability of the information. Because in that case, the Crocs, which was the Crocs company, who were the owners of the design, they argued that because their website, where design was for the first time disclosed, was in the United States, therefore the relevant public, it was unlikely that the relevant public in the European Union could have come across the disclosure of such design, and therefore this disclosure cannot be taken into account. And also it was, in that case, the matter was on the standard of proof, because what Crocs suggested, that it should be assess the likelihood of whether the information can be accessed. However, the court said that this is the matter of fact, and it actually, the design holder has to prove by fact that such information was not accessible. And the threshold of proving such fact is quite strict, I must say. Also, when assessing the searchability of information, such factors should be taken into account as a composition of the specialized circles. So, for example, in the case of smoke alarms, the disclosure was made in the Facebook account. Basically, the company who was producing smoke alarms, they published the new product, the photo of new product, in their Facebook account. And therefore, the invalidity applicant found this information and said, look, you disclosed your design in the Facebook, and therefore it should be considered as a prior disclosure, and therefore your design does not have novelty and should be declared invalid. However, the position of the board was a bit different, and in that case, the particular role was played by the specialized public. And the board considered that because the disclosure was in the Facebook account, and the Facebook is the tool for social networking, and in that particular account, the type of information was more or less targeted at the staff of the company. So the board considered that it was very unlikely for the specialized public to come to discover this information in the Facebook account, because it considered that the companies who are such specialized as producing smoking alarms and so on would not go and check the Facebook accounts of the other company. This decision was quite also criticized by the users, but I think that in that particular case, considering the particular factual circumstances, I think it was justified. Also, in the case that I mentioned, the Bangles case, the disclosure was claimed to be in the personal blog of a person. There was a product which a person who was a private individual and a blogger uploaded the photo and commented about the product. So therefore, the board considered that because of the nature of the personal blog, it cannot be expected that the specialized public would come across such a disclosure. And as I said, the most important thing is to take into account that what we are considering is the specialized public. We're not talking about the general consumers. And the specialized public, the specialized circles are designers, traders, developers. So this is the public that we are talking about. However, as you can see, the practice is not that settled yet, because in the wheel rims case, the disclosure of the rims of the wheel, In that case, the Mercedes challenged the registration of the wheel rims which were similar to theirs. And in that case, the disclosure of those wheel rims were in the Facebook account. And in that case, such information was accepted. So as you can see, the practice is not that settled yet. Also, the disclosure outside the European Union. So as I was saying, that in many cases, the design owners would say that their design was not disclosed if it was published somewhere else outside the European Union. However, the regulation does not really give this limitation, because the disclosure anywhere in the world should be considered. So therefore, also considering the nature of the internet, so it should not really matter where such information comes from. And here it's also an important factor to be mentioned, that the Article 7 of the regulation talks about the circles specialized operating within the European Union. So it does not really say that those specialized circles, designers, manufacturers, traders, they have to be the European companies. They should basically be operating in the European Union. So let's say such a global player as in the footwear industry, as the example I gave before the court, as Nike, although it's a US company, so the disclosure somewhere in the United States should be also assessed from the perspective of such big companies, because they are also operating in the European Union. So this issue has not been tackled directly by the courts, but this is the approach that the board, that the office has now. But we'll see. Maybe the general court will correct our perspective. The most complex issue for the invalidity applicants is to prove the date of disclosure, because you always have to prove that disclosure happened in the past. So when we talk about the earlier registered rights, when the invalidity applicant invokes the registered right, which was published before the contested design was applied, so there is no real problem, because you have a registration certificate, and then the office says, since it was published in official bulletin, it was considered as disclosed. So there is no issue with that. However, the most complex issue with the rights which are not registered. So how to prove in the internet that these designs were disclosed? If you submit just a printout from the internet web page where design is disclosed, you will have a date or when you print it. So in principle, this evidence does not give a lot of value, because it doesn't prove that disclosure was in the past. Sometimes you can see the information in the web page, in the printouts of when the information was uploaded or modified. This is something which is more interesting. So for example, even if you print the website today, but it might have some information that refers to the past. So for example, in such online shops as Amazon, you can go to the online shop and you see the design and the product, and you can see the indication available since the date. And the date shows to the past. So in that case, such evidence would be really valuable, because it shows that the prior design was put online on sale before that date. The information on the dates and everything which is related to the internet might be very technical. And sometimes for the office it might be very difficult and tricky to establish and to weight the evidence submitted by the parties, because it might be very technical why this date is appearing, why this date is not, it should not be taken into account for disclosure, and so on. And sometimes the parties really submit a technical information like expert opinions, and the office is not capable to assess them. So also in that case, the regulation, particularly Article 65, gives a right for the office to ask of the opinion of independent technical investigators. So for the time being, I haven't heard of any cases where the office has had such a reference to the independent experts, but maybe in the future the necessity might arise, because, as I say, sometimes it's very, very complex to assess the evidence, especially which relate to the internet and to the technical field. We also sometimes see the information that shows the date of disclosure with a timestamp, which is the service provided by some internet websites where they would put a timestamp, an electronic timestamp on your document. However, this is also true that this evidence has to be arranged beforehand. So when you already have an invalidity case pending, that's not the time to start collecting the evidence. The evidence has to be collected beforehand. Sometimes also the relevant date can be inferred from the search engines such as Google. So for example, they have such a possibility of indexing the date. So sometimes when you go to the Google search and you see Google cache and the date, so it means that Google, when they search the web pages, they make their own copies. So in that case, if you search for the website today, you can actually find that the website was cached by Google before, and it refers to the information that was in the past. It could also be an interesting way to prove the date. The most common way that we see in the office from the practical perspective of proving the date of disclosure is internet archiving. And I'm sure that those who deal with invalidity cases, you know such a tool as Wayback machine that gives you a possibility to retrieve the information how the website looked in the past. So here I would spend a little bit more time explaining a bit the particularities of this particular aspect related to the Wayback machine. So this is the online tool which is operated by a non-profit organization called Internet Archive. And this organization maintains the digital library of the internet web pages. And it has a library of internet web pages already with 20 years ago. And I've heard that it was considered as nowadays a biggest online library by this company. The service is free to everyone. And basically, really, we can see that the parties are using this service a lot. The way that the Wayback machine functions is that the company, which is called Alexa Internet, it has such a tool as web crawler. So they let this web crawler to crawl over the all existing web pages as they are, and then these web pages being archived in their system. And then the user, if you know the website, you can go to the Wayback machine, you can type in the address, and then it gives you an information with a calendar of the web pages, of the copies of this particular web page that were archived before. The only thing is that it also depends on the particular web page and on the data or the traffic of the web page. So not all the web pages are archived with the same frequency. So for example, those web pages that have low traffic data are archived maybe twice or 3 times a year. So when submitting this evidence from the Wayback machine, you have to take this into account. Also, there are some technical limitations related to the Wayback machine. So for example, it does not archive the web pages which are password protected. So the web crawler cannot enter into such a website. Also, there is a possibility to block your website from accessing of the web crawler. So for example, if you don't want your website to be archived, you can go into the Wayback machine and tick the box saying that you are not allowing the web crawler to to enter your website. Also, there are some other technical specificities and limitations of the Wayback Machine that I'm not going to enter in so much detail. But the basic principle is that although it's been treating from the legal perspective, although the evidence originating from the Wayback Machine is it's being treated differently by various jurisdictions, the practice of the office is in principle to accept such evidence. In some countries, national offices or courts are really reluctant to accept, saying because the evidence is not originating from official source because it's non-profit organization, non-governmental. However, the practice of the office is to accept, and in a number of cases, it was confirmed that this evidence can show the disclosure. However, it's also important to take into account that it's always good that this information is collaborated by another evidence, that always the more evidence you submit, the better. Disclosure in the social media, this is also an important and interesting phenomenon, that the designs can be disclosed in the social media, and sometimes the companies wouldn't even expect that simply by publishing a photo, an image of a new product, they are already disclosing it to the relevant circles. So this tool has to be really used with caution. What is important to consider when considering the disclosure in social media is whether the account has a free access. So for example, if your Facebook account has free access to everyone and you have disclosed the design in your account, therefore it's probably that such a disclosure will be taken into account. On the other hand, if your account is closed, it's less likely that the specialized public have come across your design. Also, the ownership of the account is important, because if the design is disclosed by the owner, by the design owner himself, it has to be taken into account that the owner has 12 months in order to decide whether he or she would register or not, because the disclosure during the 12th month, which is done by the designer, is not considered as a disclosure for the purposes of invalidating. The purpose of account, as I mentioned, the case with the smoke alarms. So because in that particular case, the purpose of the Facebook account was more for the social means for the employees of the companies. Therefore, the office considered that in that particular case, it was unlikely that the specialized public would have known about such a disclosure. Also, the indicators of popularity, like how many visits the website, the account has, likes, and so on, should be taken into account. So the final point that I would like to mention today is that the office has already developed some practice as regards the disclosure of the designs in the internet, which is quite a new topic. Also, these issues are being dealt with in member states. However, the level of details that the member states or national offices go into this issue is not the same. Also, considering that the regulation on designs and the directive have very similar provisions on this topic, therefore, there is a need to converge the practices of the office and of the national offices in this particular area. And in particular, because we already see emerging some differences in assessing the evidence coming from the internet, and also that the users have been complaining about this different approach. So in 2006, the Convergence analysis project was launched, because the office has this intention and the goal to converge the practices of the national offices and of the office. And as one of the topics which was brought, it was the criteria for assessing disclosure of designs in the internet. And finally, after the several rounds of review, this topic was confirmed as as a topic for the Convergence, and in 2018, in March, in this year, the first working group, which is dedicated to this Convergent project, met, and I'm also happy to be a member of that group. And the aim of the project is actually to come with a proposal of the common practice on how to assess the evidence originating from the internet. So the project will cover the issue of types of evidence acceptable, what are the relevant factors to be assessed, what are the means of disclosure, and so on. It's not an easy project, I must admit, because of specificities of the disclosure internet, because the scope is rather broad, and also because the practice and guidance from the courts is not that extensive. But I'm sure that we will succeed in producing a valuable document, a common practice, which will serve the users well, and hopefully that by 2020 you will be able to see the results of our work. Okay, so that's from my side. If you have any questions or doubts, you can ask now or during the coffee break.
Paldies Ivanauskas kungam par šo interesanto ieskatu visdažādākajos aspektos par publisku atklāšanu. Varbūt kādam ir radies kāds jautājums, vairāk tehniskāks vai juridiskāks, tad kā to pareizi darīt un atrast visus nepieciešamos pierādījumus. Lūdzu.
So, just to be clear, those historic cases you were describing, the crops.
Yes.
Who is the defendant? Who is the one that is causing the case? Like, is it during the process when the Crocs is trying to trademark or to register their design, and then the office is saying, no, we found within the internet, or whether someone else is coming in and saying, Crocs, you shouldn't register because we found it on the internet?
Yeah, okay. So, as I said, the registration procedure of the designs before the office is very simple and very fast. You check few formalities, whether the design meets a definition of design, it's not against public policy and morality, and it gets registered, and it's in the register, and the designer can use it. And only then, the interested parties can challenge the validity of the registration. So in Croc's case, what happens, they had their design registered, the original shoe. And they were trying to prevent the other parties, I think it was a French company, to use similar designs. They were suing that company in France, trying to stop them to use similar Crocs. So that company, what they said, it's not good. What we can do? So they decided to attack the Crocs design. And the problems that the Crocs had was that their design was disclosed prior to their registration. So yes?
So prior to registration means more than 12 months. Since they are designers, they can disclose and then register within 12 months. So they were trying to prove that it was done even more than 12 months.
Well, the 12-month condition applies only when the design is disclosed by the designer himself. Okay. When the design is disclosed by any other party, or not even the same design, it can be a similar design. So therefore, the 12-month rule doesn't apply. The 12-month rule is only when the design is disclosed prior by the designer, and the designer, when designing a design, he or she might want to register it because it will have a success or not. But that's only the specific provision with the design. So what happened in the Crocs case, it was that actually originally the Crocs bought the business of the shoemaking from the other company. And before buying, maybe they didn't do proper due diligence and so on. So the issue that they had, that before the registration, the design was disclosed. They showed it in the trade fair. They had some images on their website. They even started some selling. And only then, when the business started to boom, they thought, oh, it's a good thing to register it. And then they registered, and they were happy with the registration because they had it for many years, until the time came that someone said, maybe this registration isn't valid because the design, the moment when it was registered, it was not new anymore because it was disclosed beforehand. So if you are not a designer and you want to put the design on the market, first thing what you have to do is to register it, okay? And then you can publish it, put it, the images on the Facebook, because this is the risk that you run if the design is disclosed beforehand and you get the registration afterwards because you decide, oh, maybe this product is very perspective. And you will be happy with the registration unless someone tries to challenge the validity of your design and discovers that your design was disclosed beforehand. And this is also the investigative work for that invalidity applicant who has to go and dig into the past to look whether and how the design was disclosed. And this is the difficulty to find information if the design was disclosed in the internet. If it was disclosed in the real world, you can go to catalogs, you can go to whatever things that the design was disclosed. But this is the specificity of the internet, which is not really easy to prove the prior disclosure. Do I answer your?
Jā, liels paldies, un tad lūdzu nākamais jautājums. Santa.
Hello, thank you, Mr. Ivanauskas, for your interesting presentation. Since you went so deep into the explaining regarding evidence of disclosure, I will ask you a specific question also. So I think you may agree that disclosure of industrial designs has something common with disclosure of invention. I mean, the principles should be the same. But sometimes reading decisions of the UIPO, you see that the principles are not the same, at least followed. I mean, just a small example. When we've been taught about disclosure for under European Patent Convention, the key is making available to public. I mean, if some doctor thesis is put into the library, and there is a catalog where you can check that no one took this and read this is still disclosure because that was made available to public. In your presentation, you mentioned that it's important to see how many visits website has, and even in one case that was mentioned that UIPO didn't consider publication in Facebook as disclosure. Well, that's at least strange. Could you please comment that?
Yes, thank you very much. Actually, it's a very good question, and the issue that we've been debating during the first working group of this cooperation project. And we were also lucky to have a person, a representative from EPO in our working group, who actually confirmed what you say, that the practice of EPO is to consider any kind of disclosure as valid. The practice that they have developed is quite strict, but it's also quite already for some time that they have been following the same. However, the difference from EPO that we have is that specifically we have a provision in the regulation that we have to look at the circles specialized. And also the other conditions that are sorry, it's already different. In the Article 7, which says, could not reasonably have become known in the normal course of business to the specialized circles operating within the EU. So it means that what the law says that it should not be automatic. So it's not any kind of disclosure that destroys the novelty of individual characters. So here we have to really assess whether it was possibly for the possibility for these specialized circles to be aware of such a disclosure, and therefore this case with disclosure on the Facebook, this is where probably the office tried to draw the line when the disclosure was made in the private, let's say, sphere, or where the specialized public could already be aware of such a. So still the practice of the office and of the courts is not that well established on this issue, but you're right that there are differences in the assessment of disclosure.
Well, in that case, where is the line? I mean, how many visits of the website is sufficient to consider to be disclosed?
Unfortunately for me, it's very difficult to draw this benchmark, but as I mentioned during the presentation, what the court says that the overall assessment of the evidence has to be taken into account, so it cannot be said, it's on the case-by-case basis, but yes, I mean, there is also an indication that not all disclosures, not anywhere, can destroy the novelty and individual character. And it's also for the holder, for the owner of the design to prove that the disclosure was not accessible. So this is the matter of submitting proper evidence, and also the matter of what I mentioned, the taking use of the resources in the internet and proving for the invalidity applicants the actual disclosure. So it's a matter of weighting the evidence.
Paldies, Fortuns kungs, skatos tagad Vandermēlen kungs nākamais, un tad pēc tam.
Just speaking from the background of proving novelty in patents, for instance, which I think is a very different legal style. But there often you have in the common law practice evidence being submitted by way of affidavits, of written declarations. What is the practice of the IPO, of the board, if the evidence only consists of written declarations, of someone says, I have seen this before, I can't prove it anymore, there is no internet, the book is gone, the publication is gone, just written declarations, as you have sometimes in common law systems. What happens then?
True, thank you. The general principle is that declarations or affidavits can be used of proving a disclosure, and this is the proper type of evidence. That's true. It cannot be, and it's expressly stated in the regulation. However, the practice of the office, which was confirmed by the courts, is that the affidavit on its own cannot prove the disclosure. You have to show something else. So the ideal scenario would be that in the affidavit you explain how the disclosure happened, but at the same time you attach some evidence and some proof. So by merely saying, hereby I confirm that I've seen this design 5 years ago, it's not sufficient. It's also that in some jurisdictions, true that affidavits play an important role because they are maybe certified by the notary public or by the court bailiff, but nevertheless, apart just from statement that the design was disclosed, the office needs to see the actual evidence of disclosure. And in particular, because designs, they relate to the images of the product. So you have to see how and where the particular image of the design was disclosed. So it's not sufficient to say, I've seen it in the web page so many years ago. No, you have to submit the printout of the web page showing that the design was there.
Esmu tagad zāles vidū pirmais, un pēc tam uz aizmuguri nākamais. Šeit pašā sākumā.
I have a very practical also question regarding printouts. I imagine it's rather easy to make one printout also of non-existing web page. So the question is whether office takes any initiative to check itself if the other party, I don't know, is not participating, for example. Do you at least check, go into this address and to see whether such web page exists or not?
Okay, thank you very much. It's a very, very good question. The approach of the office is that of a trust. So in principle, the office trusts that the parties submit the evidence as they are and that the evidence are true. Also, it has to be taken into account that, and it's also the difference from the civil procedure, because in some countries, as in Latvia, I believe, all the evidence, when you submit by the court, they have to be certified, the copies, let's say, by the notary, by the attorney, and so on. However, the office accepts, in many cases, the printouts as they are. Also, it has to be taken into account that invalidity proceedings are inter-party proceedings. So it's also for the other party to help the office to make a just decision, to make a correct decision. So if the other party does not challenge the evidence, the office on its own would not go and investigate in principle. I also mentioned the case, the recent decision from the General Court, which is called Cases for Mobile Phones. In that case, the board had some doubts regarding the printouts. Because as I said, the recommendation is when you print the document to leave it as it is. So if the office sees that it's a normal printout, it would accept it without any doubt. However, in that case, the printout had some additional information. On the top, it had some layers providing some information with the links and so on. And then the board said, it looks very strange. And the invalidity applicant did not explain how all this information and where did it come from, because it was not a typical printout. And therefore, the Board of Appeal refused to accept such a printout. However, the General Court annulled the board decision and said, no, the printouts are okay, because, as it was later on explained by the invalidity applicant before the court, it comes from their private database, and therefore all these additional features are from there. And the court gave quite a liberal, let's say, standard, saying it has to be really something standing out in order to challenge the validity or of such evidence as a printout.
Thank you. And one more question, if
Yes.
I may. If web page is .com,
Yes.
originating from USA probably, and information is available in English, do I need to submit some additional evidence, or what this evidence could be that these specialized circles in EU has seen this information?
Okay. So, thank you. The general principle is that disclosure anywhere in the world is valid. At the same time, disclosure in the internet, in any web page, which is accessible and searchable, should be okay. And also, that information has to be accessible by the public operating in the European Union. So if you have language in English, you have ending com, in principle, nothing else should be submitted to prove that the information was accessible. Unless the other party, as it happened in Croc's case, will try to challenge saying that it was so difficult to find the web page. It was not a popular web page, because in the Croc's case, the main arguments of the Croc's was that when they launched the website in 2000, the website was very small. It was the visits were very rare, and on the top, that development of the search engines at that time, as Google, was not as it is today. Therefore, it was almost unlikely for anyone who doesn't know the web page to find it, and therefore no disclosure could be made. But the court said, if the web page was in the internet, if it was accessible in practice, technically accessible, it doesn't matter where it was, and disclosure can be proven even in that case. So I think that the standard is quite low, in the sense that if you print the web page in English, it should be okay. Even in one case, the board said that the web page from China, that had a Chinese ending, was accepted because it was in English. So therefore, the public would have probably come across. And the last point that I have to make is that nowadays the possibility of image search is quite developed. So even if the web page is in the language which are not so well understood by the business operating in the EU, still by image search, if you can find that design, it would probably be considered as disclosed, even if it is in the language which is not commonly spoken in the EU.
Thank you.
Returning back to affidavits, how office will consider if party in a case submits a number of affidavits from unrelated persons, from I mean maybe from competitors also, or something, not just from a party of the case, but also from a third party which is not involved in this case.
Mm-hmm. Thank you. Also a good point. Still, I would say that the general principle stands that the affidavit on itself is not sufficient to prove disclosure. However, it is also true that affidavits or the written statements might have different evidential value. And it's also the practice of the office says that the statement or affidavit originating from the interested party has a lower probative value than the affidavit or statement originating from the independent third parties. So, yes, the advice would be always try to look for the statements, affidavits from the third parties, but nevertheless, there has to be something more just a mere statement. So normally, I would say, well, just from the practice that if you submit just a mere statement without any additional information, probably it will not be enough, probably.
Jā, paldies, un tad varbūt vēl pašu pēdējo jautājumu, ja kāds kaut ko ir sakrājis sevi un tomēr vēlas pajautāt. Izskatās, ka bijis pietiekami. Labi, teiksim vēlreiz liels paldies.
Paldies.